Welcome to Immigration Quicktake. This is Ellie Rutledge Silver with the American Immigration Lawyers Association. This week, the Supreme Court announced it would take up Texas v. U.S., meaning it will hear the case on President Obama's executive actions on expanded DACA and DAPA. Here to discuss this announcement and what to expect next is Melissa Crow, Legal Director at the American Immigration Council. Melissa, thanks for joining me. First, what does the Supreme Court's announcement mean?
First and foremost, it means that immigrant families are finally going to have their day in court. The Supreme Court has a critical opportunity to affirm the lawfulness of the deferred action initiatives that President Obama issued in November of 2014. And hopefully they are going to lift the preliminary injunction that has blocked the implementation of these initiatives for far too long. If that happens, then up to 5 million people could get temporary relief from deportation.
The court directed both sides to also address whether the guidance violates the Take Care Clause of the Constitution. Was that expected?
Not necessarily, but I think it bodes well for a comprehensive decision that's going to prevent any further shenanigans by Texas and the other plaintiff states. Texas and the 25 other states did raise a claim under the Take Care Clause of the Constitution, and they have alleged that the president changed the law instead of taking care to faithfully execute the law. Now, interestingly, neither Judge Hainan in the district court nor the Fifth Circuit addressed this claim. But the fact that the Supreme Court has requested additional briefing on this issue suggests that they want to close any loopholes that could be a basis for a further ruling by Judge Hainan that would lead to a continued block on the implementation of these initiatives. My hope is that Texas doesn't end up having to reach the merits of this case and instead decides to dismiss it for lack of standing. What this would mean is that the court would find that any additional costs that Texas or other states might incur for having to issue driver's licenses to the intended beneficiaries of these initiatives doesn't constitute a basis for a state to go into court and challenge federal immigration policy.
What comes next in the case?
The Supreme Court is likely to schedule oral arguments in April of 2016, so before its current term ends. And between now and then, the Council and several other immigration advocacy organizations are going to be working hard to coordinate amicus briefing on behalf of a broad spectrum of stakeholders. Assuming that oral arguments happen in April, the court should issue its decision by the end of June of 2016. And we hope that the court will find that these deferred action initiatives were a valid exercise of executive authority to set immigration enforcement priorities.
Thanks, Melissa, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.